In M&A, and going back to the definition of a covenant, an action you're supposed to do or an action you are not supposed to do. Covenants in M&A are recoverable up to the full purchase price, right? Because it's an action and you can control your actions, presumably. Nobody's going to force you to go compete. You have complete control over whether or not you do the other covenants in the agreement. If you don't do what you're supposed to do, then me as the buyer should be able to get the full purchase price back from you. So that's something that should not be capped like you see some indemnification provisions.
I just got a markup to a purchase agreement back this morning. And that was one of the comments from Sellers Council, is that we only limited the 20% cap on damages to fundamental reps, but it should be limited to all damages, including breaches of covenants, which is just an absolute non-starter for exactly the point you say. And non-competes are exactly the one area I go to explain to my client why this is an absurd position, right? Because this seller could take your $5 million cash purchase price in the bank, immediately the next morning go compete against you, take all of your business and take your company. And when you go sue him, he says, okay, here's 20% of your money back. Eric, welcome back to Main Street Deals. Great to be with you today. Let's start off like we always do, but I'm going to say like we usually do because I usually forget this part, but want to give a quick bring down on the firm here and where we're at. This is already a little out of date only because we had a big day yesterday. How many deals did we close?
5. Well, between yesterday and today and this morning.
Got it. It was both.
I think at least 5. Yeah.
Yeah. So these stats aren't going to reflect those latest closings just because it usually trails a couple of days to get things in. So we're currently showing 380 deals. So this should actually be more like 385. And knowing the deals we closed, this has pushed a significant bump over 1.79, probably pushing 1.8 billion total. So huge May for us, or at least end of May. You know, states can continue to lead: Florida, Texas, California. I think it's been in that order for quite a while. It'll be interesting to see if that evolves at all. But yeah, lots of things happening, and candidly, lots of closings in the queue. I don't know what your June looks like, Eric, but I've got, I think, another 4 or 5 scheduled this upcoming month. So the stats keep ticking higher here.
Well, a lot of activity. It's interesting too. I always think of June as sort of the halfway point in the month. Obviously, it's not. The end of June is, but
yeah.
2026 is going by really fast.
So anyway, yeah, super positive update. Things are jamming, doing a ton of deals, which is part of what's raised what we wanted to talk about today. I mean, we've done a lot of talk about due diligence, reps and warranties and things like that, but we haven't really gotten into the meat of any of the covenants that get negotiated during a transaction. Today, I thought, just because it features prominently in every deal, that we'd spend some time talking about restrictive covenants. And by restrictive covenants, when we say that, we're usually referring to the non-compete is the one most people think of, but it goes beyond that. Usually a non-solicitation covenant, and that covers a few things: employees, customers, things like that. Non-disparagement is one that often gets overlooked that we try to negotiate into every deal. So it's more than just the non-compete, even though that kind of dominates the public discourse when it comes to these restrictive covenants.
Kevin, to start, I mean, why don't you tell the audience what a covenant is for those of us that are not, lawyers or weirdos? What is a covenant?
That's a great question. I was about to ask you to kind of distill down at its core what a non-compete is, but let's take a further step back before I punt that question to you. What is a covenant? That's actually a great point. In every agreement, there are different types of provisions, right? And we've talked about representations before on the podcast. Representations are certain statements of fact about the business, right? And then there are agreements to do things, right? At its most basic in the agreement, the one that everyone should be thinking of is an agreement to pay by the buyer and an agreement to transfer the business by the seller. That's the core covenant in the agreement. It's in the document itself. It is an agreement of the buyer and seller to do the thing that you're committing to do in the agreement to sell the business.
Yeah.
That
it's
said,
an action. It's an action. You're either
it's an action,
doing it,
yeah.
you're doing something, or you're not doing something, right? There are
Correct.
negative covenants which say, do not do this thing, or there are covenants that say you must do this thing. So it's activity.
Yeah, that's what I was about to say. And in the legal world, you'll hear it referred to as an affirmative covenant or a negative covenant, right? An affirmative is I will do a thing. A negative covenant is I will not do a thing, right? And so in every agreement, obviously there's the basic covenant to actually buy transfer the business for the money, the cash paid. But there's usually a series of a whole bunch of other covenants and affirmative and negative covenants that the buyers and sellers are going to make. And the restrictive covenants are one subset of those covenants that you should find, and we could talk about that, but that you should find in every acquisition document, right? There really should not be a world other than subject to very, very limited exceptions where you do not have a series of restrictive covenants. These are negative covenants where the seller agrees not to do certain things. So a restrictive covenant is a series of negative covenants that the seller's agreeing not to do, right? The non-compete is the seller agreeing, I will not go and take certain actions to compete against the business, right? So let's start there, Eric, and break down at its kind of fundamental core, the non-compete and what it does, like why we have this in every acquisition agreement.
Yeah. Well, and I'll start off by saying that non-competes sort of get confused by folks because non-competes are fairly controversial in the employment space. These are different than that. This is a business sale non-compete. And people always tell me every time I post about non-competes, they're like, non-competes are not enforceable. Non-competes have been struck down. Well, no, the FTC a few years ago tried to make employment-related non-competes universally unenforceable nationally, except for some limited exceptions. That was employment-specific. Even in that case, they excluded business sale non-competes. The state of California and others have some pretty strict prohibitions on employment-related non-competes. But even in California, a business-related non-compete is still enforceable. And it's enforceable for a long period of time, typically in most states between 3 to 7 years, because in the absence of business sale non-competes, the business buying marketplace would die or it would change. Yeah. I don't know how it would change, but the way it exists today would not be possible. And the reason it would not be possible is when you sell a business or when you buy a business from a seller, that seller is uniquely positioned to kick your ass if they decided to do that post-closing, if they were able to do that. Right?
Yeah.
Think about it just practically and very simply, right? If you bought SMB Law Group from us tomorrow and you gave Kevin and I $10 million, which is probably $9.5 million more than it's worth, but for sake of
I thought you were going to say a ninth of what you should pay, but anyway,
yeah,
I digress.
Yeah, okay, either way. Point being, you give us $10 million for SMB Law Group tomorrow. You take our firm, you take our brand, you take all of our employees, you take all of our clients. And your goal is to make money off of those resources. Well, Kevin and I, if we weren't stopped, could very quickly call up all of our lawyers. We have great relationships with them and say, hey, you know that new guy that just bought the business? Forget about that guy. He's going to run that into the ground. We just started a new law firm, called whatever, come work for us. In about 10 minutes, we could get all of the existing lawyers to come work for us. We could call all the clients.
All of our referral partners, all of our former clients. Yeah.
It would be very quick for us to be able to sort of go and capture all of the stuff that you just gave us $10 million for. That is why business sale non-competes exist. If you took those away, nobody in their right mind would ever give anybody money for a business in the absence of maybe like an earn-out or some sort of contingent compensation structure that sort of prohibits that. And so under the law, even in very restrictive jurisdictions like California, they still allow for business sale non-competes. Yeah. Now, I'll tell you what Florida's case law says. I'm licensed in Florida, Texas, and Colorado. In Florida, a business sale non-compete has to be rationally related or reasonably related to legitimate business purposes. Okay. So you're thinking about both the scope meaning what can I restrict somebody from and the duration for how long. And what the law says is those have to be reasonably related to legitimate business purposes. Meaning, when you think about scope first, right? What can I tell somebody that they can't do? Well, if you're coming to buy a law firm from me, right, and you buy my law firm, you cannot tell me that I can't go open a pest control business or a car wash or something that is not reasonably related to the legitimate business purpose, which is running a law firm, right? And when you think about, what is a business acquisition and go all the way back to sort of the philosophical underpinnings, you're talking about buying a set of assets that produce revenue. You're buying that revenue, that cash flow, right? And so there are things that are sort of going to cut into that cash flow that if I went and did them, it would undermine your ability to get the benefit of what you bought, that cash flow, and other things that are just totally unrelated, right? Me running a pest control business is not in any way going to stop you from getting that revenue that you paid for.
Yeah.
If, however, I opened up a law firm, obviously that would probably significantly impact that revenue. Or, in sort of a middle ground case, if I went and opened up like a LOI negotiation service, right? Come to me and I'm going to use AI to negotiate LOIs. Well, that probably will cut into a lot of your lead flow, a lot of your clientele. And so even though that's not maybe the practice of law, it still is sort of reasonably related to legitimate business purposes. So you could say in your non-compete that you're going to stay, that I'm going to stay out of all legal services. I'm not going to do, you could probably even say, Eric, you're not going to do anything in M&A, right? You're not going to do anything in M&A and stay out of M&A. Anything that comes to you in M&A, send it my way. So that's
and if I could pause you there, that's an important distinction and probably the right time to bring up that the law on non-competes varies from state to state, right? That it's super important. There is no one size fits all rule. So the rule in Texas is that the restriction has to be it has to be limited in scope to the business, what the business actually does. So in Texas, right, you probably couldn't say anything related to M&A because if I want to go out and start brokering businesses, SMB Law Group doesn't do that. So even though it's tangential to the M&A space, that's nothing. That has nothing to do with what SMB Law Group actually does. That would be an overly broad restriction in Texas because you can only limit it to what the business actually does, right? And so it's really important to understand the distinctions across the states and make sure you're not just relying on broad-based rules because that scope of activity is one that can get you if you assume the New Hampshire rule is like the Florida rule is. You could land yourself in a little bit of hot water.
Yeah, and we'll talk about enforcement in just a second and sort of how different states think about enforcement.
For sure.
But so that's bucket number one is what can you tell the person that they can and cannot do? And it has to be, again, reasonably related to legitimate business purposes.
Yeah.
Now, the second element of it is duration, right? And there are, varying, again, case law state to state. Now, employment-related non-competes in states that allow them are limited to very short durations. Typically 6 months to 2 years on a high end is what you would see in an employment-related non-compete. Yeah. In a business sale non-compete, you're going to see a much longer duration. What the state of Florida says is that as long as it is within the band of 3 to 7 years, then it is presumptively enforceable, meaning that is under the law, a reasonable period of time, 3 to 7 years, to keep that seller out of your business activity. If it's less than 3 or more than 7, it's going to be presumptively unenforceable. And you're going to have to, the person bringing the challenge is going to have to overcome the presumption, if that makes sense.
Yeah, it's a
You go
burden
ahead.
shifting rule. And that's another one that will vary wildly state to state. Not all states have that. Florida does have a bright line rule in terms of who bears the burden of proof. It's not a guarantee that it's enforceable, but it shifts the burden of proof. If you're in that 3 to 7 year band, the person, challenging the non-compete has to prove that it was, that it was impermissible. And then that burden shifts if it's outside. If you're trying to enforce a 10-year non-compete, the burden is now on the enforcing party to prove that it is reasonable. That also varies pretty wildly state to state.
Yeah, absolutely. And so, if you're within that band, then, you sort of can presume. Now, what the SBA lenders, if you're an SBA buyer, and many of our clients, about half of our clients are SBA buyers, they almost universally require a minimum of 5 years. Now, that's not hardwired into the SBA SOPs. That is something that lenders have sort of made market based on the requirement for prudent lending standards. They have a sort of a universal guidance that their lending standards have to be prudent. So when you're in SBA land, you really want to assume you're going to get 5 years, right? Which is surprising to some people. But assume you're going to get 5 years. Now, in some instances, sellers will push for less than that. We could talk about sort of the negotiation tactics and also sort of what that signals, right? If you've got a seller who is selling and is also fighting you on a non-compete, that can send you signals about their intentions for life after closing, right? If somebody is 70 years old and sailing off into the sunset, then they don't give a shit if it's 3 years or 100, they're done, right? But if they're saying, hey, I need it 3 years versus 5, that's an indication. I always sort of make the joke that a 3-year non-compete is 2 years of rest and 1 year of preparation to come kick your ass. 3 years is going to go by really fast. For any of you who've ever bought a business, you'll get to the 3-year mark in the blink of an eye, and you may be not fully out of that sort of metaphorical J curve at that point in time. And so if you got a seller pushing for 3 years, you really want to think long and hard about whether or not you want to do the deal, frankly.
Yeah.
Now, different states interpret these differently, as Kevin noted, and what they do if you get the non-compete wrong, right? If you tell somebody who's running a car wash, for example, you buy a car wash in Capel, Texas, but it says that they can't even run a car wash over here in Windermere, Florida, and they do, and you want to sue them on the non-compete, and they say, no, they push back and say your non-compete's not enforceable. What a judge is going to do is one of two things. They're either going to blue pencil it or they're going to red pencil it, depending on the state that you're in. If you're in a blue pencil state, what a judge is going to do is he's going to look at that non-compete and he's going to decide whether or not what is the enforceable limitation. He's going to say, I'm going to change it, right? You said no car washes nationally, but the car wash that you sold is only in Capel, Texas. It really only draws clients from sort of that broader county related area. So I'm just going to reduce it to the county. If you're in a red pencil state, what the judge is going to do is he's actually going to throw the whole thing out, right? He's going to throw the whole non-compete out and completely strike that provision and say it was written in an unenforceable way. So I'm not going to try to recreate it. It's just not enforceable universally. So those are two very different outcomes for somebody. If you buy a business, you overstep with a non-compete and then it gets completely thrown out, you could potentially have a problem.
And that one's relatively rare. I'm relying a little bit just on searching quickly because none of the states I'm licensed in are red pencil states. But based on what I'm seeing, a couple like Wisconsin, for example, South Carolina, maybe red pencil states. So those are states where, to your point, if any of it is overly broad and unenforceable, the whole thing gets thrown out. But that's luckily not necessarily like the predominant rule in most places. That's kind of going out of vogue.
Now, I would say I want to err on the side of just not caring whether I'm in a red pencil state or a blue pencil state and just getting it right. Because if you're in a blue pencil state, then you're relying on a judge to tell you what is reasonable. And I don't want to rely on that, right?
Yes.
I want to look at the business. You've done financial diligence. You've sort of done business diligence. You've got a sense of where the businesses' clients are coming from, or you should. If you don't, then you should. And, you want to be able to make a business case that all you're trying to do is cover off the areas where the revenue and earnings that you're paying for is coming from, right? If you've got a tax practice in Tampa, Florida, well, where are those customers driving from, right? Is it in-person tax practice and they're driving from Hillsborough County only and maybe some surrounding counties? Well, then that's all you really need, right? And so just get it right in the first instance. Now, there are some cases where we see this a lot with private equity funds where they have plans for the business, right? They're executing a roll-up strategy. So they want to tell the seller that they can't operate in all of the various jurisdictions that they are also planning to do business in or have other business operations in. That's not how it works, guys, right?
Yeah.
That's not at all how it works. But if you're a pool services business and you sell pool supplies nationally, right? Or if you're a SaaS business and you can supply clients anywhere, or some sort of e-commerce business that can ship things nationally, then yeah, having a national or global non-compete isn't crazy. So, that's sort of how the legal mechanics of it work. The only thing I would add, which is interesting, is there are a number of professions, and this is just to sort of double click on the idea that, employment versus business sale non-competes, in healthcare. For physicians, for example, you cannot have non-competes in many cases for physicians. You cannot have non-competes in many cases for attorneys.
Yep.
But when you're talking about selling a medical practice or selling a law firm, you can put a business sale non-compete on those individuals, even in those instances. What you can't do is you can't put a non-compete on their key people who happen to be doctors or attorneys. So that's maybe a little bit different than other industries where you could say, hey, like your, number one operator in your towing business, like I want him to sign a non-compete too.
Yeah.
You can't do that in those professions, but you can still non-compete out the seller.
Yeah. Just to double click on one more thing there, and I know we're getting a little bit into the weeds, but I just wanted to point out that as we're talking about enforceability here, in the blue pencil states, there's a further distinction between discretionary and mandatory, right? So there are some states where a judge is required to blue pencil if something's overly broad. Texas is one of those. I only bring it up because Texas is unique in that aspect. The vast majority of states, including very common ones like Delaware and whatever, they're discretionary. The judge is able to blue pencil if they want to, and you move on. In Texas, it's mandatory. The court is required to refine and adjust the language of the non-compete to be enforceable. But there's a hugely significant trade-off, and that is that the court is barred from awarding financial or monetary damages for the overly broad provision up to the point where it was blue penciled. So that's super important. Back to your point of like, you could be aggressive and just put a broad non-compete in if you're buying a business in Texas and say, hey, the court's going to blue pencil it anyway if I'm being overly aggressive. That may be true. They will blue pencil it and make it, and reduce the scope or duration or whatever to the level that it will be enforceable. But up until the court does that, you will not get any damages. And by that point, the damage may be already catastrophic to your business. So again, just to like further underscore, it's while there are blue pencil laws in most states, it's important not to be overly aggressive here and just rely on that fact of like, oh, if we get a little too aggressive here, it'll just get enforced to the level it's supposed to, because you could be giving up a lot of rights and recourse in doing that. So I think on the blue penciling, red penciling, whatever, we've beat that to death. Let's talk for a second a little bit about actual enforceability, Eric.
And before we do that, though, let's talk about exceptions, right? What's very common, I think, what you should expect if you're buying a business is that most sellers are not the 70-year-old, I'm going to do nothing for the rest of my life, right? Many of them are I'm tired in this business. I don't really want to do this anymore. I've got this other thing that's going better, so I want to get this other thing off my plate. Or they're like, hey, I'm experienced in the restaurant industry, so although I would like, I will not compete with you, I would like to go consult, or do things that are sort of ancillary in a way that is not competitive with you. And so you should expect that there will be some exceptions or some carve-outs to your non-compete that will be talked about in the
It's a great point.
negotiation process. And again, it all comes back to that thesis of, or that baseline principle of, is that activity that they're talking about a part of, or will it impact the creation of the revenue or the earnings that I'm paying for?
Yes.
So that's where you
Yeah.
start with it. But yeah, let's talk about enforcement, Kevin. And you and I have talked to many litigators about this in our life. We've seen many real instances of unfortunate competition from sellers, some nefarious, some incidental, the difference between frozen yogurt and ice cream suddenly being litigated. And, in a prior life, we had an interview with a experienced litigator that, from a former podcast of ours. And, he sort of took us through that. So why don't we talk about sort of what we've learned about non-compete enforcement over the years and then some real examples that we've seen.
Yeah, I think the biggest takeaway there, just to cut straight to the chase, is, non-competes are enforceable legal covenants. You have a right to enforce them. In egregious and simple cases, they're pretty cut and dry to show you can't do this under the agreement. You literally did this, therefore you violated the covenant. The problem, and this is what the litigator we had on our prior podcast broke down, and I do think we should share that episode in the show notes, is that, an enforceable right is only good insofar as you have the practical capacity to enforce that right. So just to talk through briefly what it means to enforce a non-compete, right? There's a few steps here. If you find out that a seller is violating a non-compete, your first step is to reach out to them and say, hey, you're violating the non-compete, knock it off, right? If it's completely accidental, you're going to get a mea culpa or maybe a little bit of like, oh, I didn't think I was, let's talk about it, right? The vast majority of cases, it doesn't usually go that well, right? You're told to, go pound sand or you're ignored or something. That's going to escalate then to hiring a lawyer to send a formal demand letter for breach of contract and breach of covenant under the purchase agreement. That already starts the lawyer clock, right? The time clock to start incurring charges, right? Your lawyer now needs to get up to speed on the contract, the deal, have some meetings with you to understand what's going on, draft the letter, have some back and forth. You could be thousands of dollars into legal bills just to get that original demand letter out. Assuming they still ignore you or tell you to go pound sand, now you're talking about actual litigation. And what this litigator told us is on the conservative side, you're probably looking at $40,000 to $75,000 to get to the point of filing a legal action and getting an actual injunction from a court. It's a court order that, by operational law of the court, they're ordering the seller to cease that activity. That's what an injunction is. That could be $40,000, $50,000, $60,000 to get to the point of a permanent injunction and hold a trial for damages to recoup some of the losses caused by the competition. In almost all cases, you're into the six figures in legal fees, right? And so stop and think about that if you're a buyer, right? You just took out an SBA loan at 80% leverage, put in 10% cash equity infusion, which is probably pretty close to your life savings for many of you. You have a little bit of working capital on the business. It's 4 months in. You're struggling for life to keep your head above water and keep the business afloat, keep cash flow going. And the seller, the one person on earth uniquely positioned to absolutely destroy your business, as you put it in our example earlier, in 10 minutes, right, is sitting on $4 million in their bank account while you're being expected to pay $50,000 to $100,000, right, to go enforce that right. If that's sounding really difficult and scary to you, it should be, because the problem with a lot of buyers and what they end up confronting is this is an egregious case of violating the non-compete. It's cut and dry. It's very clear that I would win this case, but it's going to cost me so much time, emotional strain, and money to get that final injunction and award of damages that it's going to further put your business at risk, right? And that's the practical problem of a non-compete in this place, right? A non-compete's very enforceable. If you're a mid-market private equity fund sitting on a pile of cash, hell yeah, we're going to go throw couple $100,000 at this seller to beat him down and get an injunction. If you're a self-funded searcher that's fully levered with a personally guaranteed SBA loan and very little by way of assets left after you've given the seller a war chest to fight you in this litigation, that could be an existential threat to your business. And it's something that should be considered, that while these covenants are enforceable and they're important covenants, from a practical perspective, they may be very difficult to actually go enforce.
Yeah. Well, and I think I think the way that Greg described it when we spoke with him about this topic was, you have to decide, is it just a annoyance, right, that I should put my head down and outrun, which, frankly is sort of business, in the ordinary course, or is it an existential threat to the business, right? Is this going to kill the business? And if it's going to kill the business, then yeah, you need to exhaust all possible remedies. In addition to putting your head down and running, you also should, seek litigation and spend whatever you need to spend to try to stop the seller. And by the way, the damages for a non-compete violation are injunction, right? They have to stop what they're doing. And of course, you're probably thinking, well, what's going to stop them if they're, already violating in the first place? Is a court telling them to stop going to actually work? And that's a fair question. We've seen some non-compete examples of people that are truly terrible people that don't give a shit.
Yeah.
But, then you're talking about actually facing sort of court sanctions and jail time. So
yeah,
presumably they will stop. And then it's disgorgement. It's actually taking the money that they've profited from them.
That's right.
They never had they never had the right to earn it in the first place. You should be able to go get that back. And I'll tell you, in M&A, and going back to the definition of a covenant, an action you're supposed to do or an action you are not supposed to do, right? Covenants in M&A are recoverable up to the full purchase price, right? Because it's an action and you can control your actions, presumably. Nobody's going to force you to go compete. Nobody is going to, you have complete control over whether or not you do the other covenants in the agreement. So if you don't do what you're supposed to do, then me as the buyer should be able to get the full purchase price back from you. So that's something that should not be capped. Like you see some indemnification provisions that should be recoverable up to the full purchase price, or frankly uncapped at all. Although in market practice, you'll see it capped at the purchase price.
Yeah, I just, very timely comment. I just got a markup to a purchase agreement back this morning, and that was one of the comments from Sellers Counsel, is that we only limited the 20% cap on damages to fundamental reps, but it should be limited to all damages, including breaches of covenants, which is just an absolute non-starter for exactly the point you say.
That's got to be one of those AI generated. I've ran my contract through Claude, and Claude thinks
Well, that's the fun part about using AI in today's modern legal world, because, people that don't configure their AI tools, it's very obvious, right? And one of the hallmarks of Claude is levels of blue shading on tables, which is, I'll give you a guess how this issues list table was formatted with different shades of blue. Like, it was very clearly an AI.
Oh, output, it's the Claude. The Claude format's got underlines in the title too.
But that's the thing here. If you're not paying attention and process this stuff through, and non-competes are exactly the one area I go to explain to my client why this is an absurd position, right? Because this seller could take your $5 million cash purchase price in the bank, immediately the next morning go compete against you, take all of your business and take your company. And when you go sue him, he says, okay, here's 20% of your money back. And he keeps $4 million and your
absolutely.
business. It's an absurd
I've had to make that argument in deals where I had a tax lawyer actually dying on a hill that, covenants should be capped. And that's exactly what I told them. I said, if I was your client, I would take that 20%, give it right back, and get right back to work.
Yeah.
And they freaked out because the client was on the call and how dare you? We would never do that. Well, then what do you care? Why are you fighting tooth and nail to have it capped if you'd never do that, right? You have complete control over this.
Yeah.
So those are some of the fun of non-compete negotiations. Kevin, we got 7 minutes left. We want to talk a little bit about non-solicits as well.
I'm glad you asked, because I was about to say that. Let's talk for a second about non-solicit. So there's in most restrictive covenants, there's going to be two types of non-solicitation covenants: one against customers, one against employees. So break down for us the difference between the two, Eric, and what are we trying to solve for here?
Yeah, I mean, it's the same thing as the non-compete scenario. And again, if you're not competing, you probably arguably don't really have a need for the customers, right? Because there's two different categories: customers, suppliers. In some instances, especially, if you've got a supplier who is, exclusive or, only produces whatever certain type of thing. And obviously your people as well, right? If they come, and even if they start a different business that's maybe not competitive, if they call up all of your people and start harassing your customers and suppliers, then you've got a problem, right? Again, you're not getting the benefit of what you paid for. A big component of these businesses is people, right? When you think about the machine that produces revenue, people in many cases are producing a lot of that revenue. If they come take all your best salespeople, even if it's in a different industry, that's a huge problem for you, right? So you, in addition to saying, hey, you're not going to compete, you also say, hey, for a period of time, you're also not going to talk to my people. You're not going to talk to my customers. You're not going to talk to my suppliers. And we've seen it in the past too. We had a client who they bought a business, and it was in the pool services space, and the seller took the customer list and started soliciting all of the customers for handyman services.
Yeah.
And the buyer was like, what the hell, man? Like, all my clients are ticked off because you're harassing them, right?
Yeah.
You're using that information sort of in an annoying way, and it's reflecting poorly on us, right? And so, that is simple as saying, now, Kevin, the restrictions on those aren't as robust, right? You can't have 5 years of non-solicit protection. What's doable there?
Yeah, I mean, it ranges. I would say what we usually end up seeing, at least on the customer side, I usually see a little more aggressive and maybe 1 or 2 years or something like that. On the employee side, pretty customary to be limited to like 6 to 12 months, right? At the end of the day, you can't stop too much employee mobility. And if they want to leave, you probably don't want them there anyway. What you don't want is to create a scenario where the seller, day one after closing, when they sell their law firm, they go start an M&A brokerage and immediately come back and take the executive assistant you left behind, the billing coordinator you left behind, et cetera, right? So with some time, you can replace people and things like that. So they don't last forever. I would say 6 to 12 months is kind of the norm that I would see on an employee non-solicitation covenant.
Yep. Is there anything else that's worth talking about sort of in the restrictive covenant bucket?
I think it just bears noting the kind of final piece here. Certainly don't need to beat this one to death, but non-disparagement. I think this gets overlooked in a lot of transactions. And the last thing you want is in the months after closing, when things get tense with the seller because you're arguing over working capital and whatever it is, the last thing you want is them taking to LinkedIn and starting to chirp about the new owner of SMB Law Group and how they're, being super aggressive and things like that. Usually it's a pretty short covenant, but you almost always want a non-disparagement in there that says you will not go make public statements that are damaging to the reputation and goodwill of the company. Again, in the vast majority of small businesses, what you are paying for when you pay $5 million for a business, 4.8 million of those dollars in the vast majority of these small businesses is for goodwill. It's for brand equity. It's for brand recognition. It's for customer relationships. And you do not want any avenue for the seller to go damage those things. And they can do a lot of damage, even if not publicly. I've had scenarios with clients where, remember, the seller may have employed these employees for 25 years and have close personal relationships. And if they invite your general manager over to dinner on a Friday night and start going on and on about how awful of a person you are because you're in a dispute over working capital, that hurts your goodwill and relationship with that employee. And so non-disparagement, something I think is overlooked when I'm doing sell side, and almost every deal, I almost never see it, which of course I'm not going to offer it, but in a buy side deal, it's absolutely something you want to get in there.
Well, and I can think of one specific example too, and you don't always get this one, right? And sellers
Correct.
sometimes fight this one just on a principle basis. So, I had one seller's counsel tell me that it feels un-American. It feels un-American to tell my guy what he can and can't do. Well,
you can't tell me what I can and can't say. That violates the First Amendment, Eric.
Well, and we had a business acquisition where the seller was, someone who was uniquely positioned in the community, and he had a promissory note, and the business sort of struggled a little bit post-closing, and so there was risk that the note wasn't going to get paid back. And now you've got this seller who's got like a major megaphone, major Facebook group, power in the community to sort of just go and annihilate the business once he's already got his cash and knowing he's not going to get his promissory note paid. Well, F him, let's burn it down, right? And without that non-disparagement in place, you don't have the ability to sort of stop them from doing that. So there can be instances where the seller, relationships sour post-closing with sellers all the time. That is not unusual at all for you to close on the business and then quickly find out that you don't like the seller and they don't like you, or there are problems and there becomes sort of a dispute. And if that seller, they very well may, even with nothing to gain, say, I want to burn you down.
Yeah.
And if they do, and if they put you out of business and put you into bankruptcy, then there's a good case that their non-compete goes away, they can get back to work, or at least in their mind, right? And so it is possible that putting you out of business means they get to get back to work. And so they might start working on that. And if you can't stop them from talking, you got a big problem. So an important provision. Yeah. And
let's end on a high note there, Eric, with existential threat for the business.
Non-disparagements. Yeah, I mean, it's not all sunshine and rainbows, right? And I think at some point there are more covenants in the purchase agreement. The requirement to pay money is a covenant. There is a provision called further assurances, which is really important. And we've seen business buyers have to litigate the further assurances provision to sort of get assets and kind of close things out. So, at some point we will sort of just crack open a purchase agreement and go through all of the miscellaneous stuff that never gets talked about. People are like, why are these purchase agreements, 40, 50, 60, sometimes 100 pages? Well, there's a lot of stuff in there that could matter for you post-closing. And at some point, so stay tuned, because at some point we will just sort of go through all of it and tell you why it's there. And, before long, you'll be one of us weirdos that wants a 100-page purchase agreement. Not that we do, but you get the point. So.
No, 100%. So with that, let's wrap it up there. Thanks again for sticking with us for another week. As always, like, subscribe, share with a friend, sound off in the comments, or reach out to us by email if there are topics or guests that you want to hear from. And with that, Eric, I'll give you the last word.
Smash the like and subscribe button. Have a good day, Kevin. Talk to you soon. Bye.
See ya.